Okay, let's go.
Hey you guys, welcome back for another video. Make sure as you come in you like and share this video. Also, if you haven't subscribed, make sure you hit that subscribe button. Also, make sure that your notification bells are set so you are notified every single time I drop a new video. Okay, you guys, a supporter came in my inbox a couple of weeks ago and asked me, hey, Miss Shawn, can you give us some more insight about the all or nothing law? And of course, you know, it's been a couple of weeks and I do apologize. I had to do a lot of more extensive research as some fellow attorneys and plus, you know, with other things being taken care of, I'm just now doing the video. So my apologies. But I will tell you that the all or nothing law is basically frowned upon in the legal system. The U.S. Supreme Court definitely frowns upon the all or nothing because it can be sometimes used as a form of coercion. And I will explain that to you. And I'll also give you an example of all or nothing and how they're not using it. They try to avoid it, okay? But I will tell you this. Anytime that a person is charged, just like in the Romika case where Holly Johnson is charged with first-degree murder, she's charged with first-degree murder. However, if the prosecutor at any time feels that they cannot prove first-degree murder, they will probably go to the defense and ask them to do a plea agreement for second-degree murder. The defense, that is their choice if they want to take the plea agreement. They can easily turn the plea agreement down. That is with any criminal case. Any criminal case. A plea agreement is asking the defendant to plead to a lesser charge if the prosecutor feels they do not meet the elements of the higher charge. That's with all criminal cases, you guys. That's why there's so many more plea agreements than they are cases going to trial. But in the cases that are going to trial, the question is, once it goes to trial, can the judge or prosecutor implement second degree as an option to jurors? And the answer to that question is absolutely yes. And I'm going to give you an example of a case where they just did that and how it is very common in criminal court. All right, so what is the all or nothing coercion? It is a legal concept used in criminal trials to describe a situation where a jury is forced into an artificial choice between only two extreme outcomes: conviction on the highest charge or complete acquittal, when the evidence could reasonably support an intermediate verdict. Courts view this as improper because it can distort the jury's fact-finding role. Now, when does this usually occur? The prosecution charges a serious offense, such as, once again, first-degree murder. The evidence supports some level of criminal liability, but not necessarily the highest charge. And the jury is not given a lesser included offense, which could be second-degree murder. In that scenario, juries who believe the defendant is guilty of something, but not this, are placed under pressure to either convict on a charge they believe is too severe or acquit someone they believe acted unlawfully. See, that right there can put juries into a very conflicting situation. That is how deadlocked juries end up in, or wrongful acquittals are done. That is how people end up with deadlock. If you ever want to wonder why people end up deadlocked, is because you know they can't find enough evidence to convict them on that, but they can't let the person walk either. But they don't have an in-between charge. Now, why the Supreme Court has a problem with this? Basically, jurors must be allowed to return a verdict that accurately reflects their factual findings, and denying a lesser included offense can force an unjust verdict. This is why judges are required to give lesser included instructions whenever the evidence supports them, even over objective from either side. So what does that mean? That means that at any time during a trial, during jury instructions, if the judge sees that there needs to be a secondary option to the jury, he would then consult with both the prosecutor and the defense and say, hey, listen, what do you think about putting second-degree murder in? At this time, it does not matter if the prosecution agrees and the defense agrees, or the prosecution disagrees and the defense disagrees. If the judge deems it necessary, he or she can put it in the jury instruction. He does not need permission from the prosecution nor the defense to do that. And why is because to prevent any type of deadlocked jury, to prevent any type of error in the law or a wrongful acquittal or anything that will cause for them having to do a whole nother trial. So that's why they are able to do that. So what is the bottom line? The all or nothing coercion is avoided by providing lesser included offense instructions, allowing jurors to match the verdict to the evidence, and protecting the integrity of the verdict and the defendant's due process rights. Now I'm going to give you guys an example of a case out of Illinois that avoided the all or nothing coercion. So you guys remember the Sonia Massie case, correct? So you remember Sean Grayson. Sean Grayson was the sheriff deputy that shot 31-year-old she was 36, fatally after she called for 911 for help with a prowler at her home in Springfield, Illinois. Grayson claimed self-defense, same as Holly Johnson, saying he feared Massie would throw a pot of boiling water at him, but a jury convicted him of second-degree murder in October of 2025, finding his belief that deadly force was necessary was unreasonable. Now, I want you guys to listen to how this verdict affected the family, and then we're going to go over exactly what he was charged with.
Tonight in Illinois, former Sheriff's Deputy Sean Grayson guilty of second-degree murder in the shooting of 36-year-old Sonia Massie.
It's guilty. Second degree.
The verdict carrying a sentence of up to 20 years in prison, but Massie's family and other supporters had been hoping for a conviction on first-degree murder.
I'm fueled by rage right now. If you get an officer that says he's going to shoot you in the face, and then he shoots you in the face, and you only get second-degree murder?
Grayson stoic as the verdict was read. The jury ultimately finding Grayson shot Massie in her kitchen last year and that his claim of needing to use deadly force was unreasonable. This after Grayson testified he perceived Massie's behavior as a threat. The Springfield mother of two had called 911 about a possible prowler picking up a pot of boiling water and saying, prosecutors arguing Grayson could have left Massie's home after she ducked behind her counter and apologized. Tonight, Massie's father angry but hopeful Grayson will receive the maximum sentence.
Because he showed no remorse. He was so cocky throughout this whole trial.
You felt like he was cocky?
Oh, yeah. Until today. Until he was convicted. Yeah. That knocked the smirk off.
All right. So on July 17, 2024, Grayson was charged with 3 counts of first-degree murder, aggravated battery with a firearm, official misconduct. These additional charges, battery and misconduct, were later dropped, leaving the murder charges as the primary focus at trial. Grayson pleaded not guilty, and the case was tried in Peoria County in October 2025 due to pretrial publicity in Sangamon County. After deliberations, the jury acquitted Grayson of all first-degree murder counts, but found him guilty of second-degree murder. Second-degree murder in Illinois applies when intentional killing occurs, but there is evidence that the defendant acted under imperfect self-defense or was seriously provoked such that the perception, even if unreasonable, influenced the use of force. The conviction carries a possible sentence of 4 to 20 years in prison, and probation remains a sentencing option. So this goes back, as you can see, Sean Grayson was charged with 3 counts of first-degree murder. He was not charged with second degree. They didn't even ask him for a plea of second degree, or maybe the defense turned it down. However, during the course of the trial, the judge decided to include second-degree murder in the jury instructions as a lesser included offense of first-degree murder. This is a standard and legally required practice when the evidence could reasonably support more than one homicide classification under state law in Illinois. However, the judge does not decide whether second-degree murder occurred. Even though he thinks the evidence may support it, he doesn't decide that, but he gives the option to the jury. The judge decides only whether a rational jury could find it based on the evidence presented. Once that threshold is met, the jury must be instructed on first-degree murder, second-degree murder, and any other applicable lesser offenses. This protects the integrity of the verdict and prevents all or nothing coercion. So how exactly does that look in a trial? Okay, the Sonia Massie trial. In the homicide, first-degree murder equals intent, no mitigation. Second-degree murder equals intent with mitigation, but in perfect self-defense, which means that in their mind, they thought or deemed it reasonable to take someone's life. So if a jury believes the killing was intentional and unlawful, but the defendant's perception was impaired or unreasonable, then second-degree murder is the legally correct outcome. Removing that option would force jurors into an all or nothing decision, which the law seeks to prevent. So how does all this play into the Romika case concerning Quadajah Holly Johnson? Well, Quadajah is charged with first-degree murder. If the prosecutor feels that they do not meet the elements or have the elements to prove first degree, they can go to Holly's defense team and say, hey, listen, we will offer you a plea agreement. It is up to Holly and her defense team whether they want to take the second-degree murder plea agreement or not, or they can say, hey, let's go to trial. During the course of that trial, if the judge sees that there are some legal facts or legal presentations or evidence that possibly could support second-degree murder, he has the option to consult with the prosecutor and the defense, let them know, hey, what do you think about implementing this? It does not matter if the prosecutor or the defense agrees or disagrees. If the judge sees fit that he needs to implement that in jury instructions, he is allowed to do so by law. And this prevents any type of legal errors or deadlock in a trial. Now, I'm going to say this as I say in all of my videos. Do your own research. It is definitely out there. If you are not sure about anything that you may hear out in your community or out on social media, go and consult with your local attorney or your local, legal people in your area and ask them these questions. You're not going to get the answer all the time on social media because most of the time people are implementing their opinion and they're not doing enough back research to understand and explain the law. Me, myself, as I always say, and I will put up my disclaimer, I am a paralegal, not a lawyer. This video is general educational purposes only and not legal advice. I'm discussing general legal concepts based on publicly available information, and laws vary by jurisdiction. All right, you guys, that is the end of my commentary, and I thank you so much for joining me for another video. Please make sure you leave your comments down below and tell me what you think. Also, don't forget to like, comment, and share this video, and I will see you guys on the next video.